Hey, good day to you. This is Stan Pierchoski with Pierchoski Estate Law, and this is the Ask Stan show every Thursday at 12 noon, where I answer all your estate planning questions submitted throughout the week. If you have a question about wills, trusts, Medicaid pre-planning, Medicaid crisis planning, the nursing home, or just estate planning in general, just send them to me here on Facebook or call me at 363-7222 or email me at pierchoskiestatelaw@gmail.com. I'll answer them live on WKSR Radio, and we post them here on the Ask Stan show every Thursday. So, let's get right to it.
Well, Stan Pierchoski oldie of the week that he picks out in the letter this morning. Good song. Thanks, sir.
That was back in the days when they sort of felt a need to put those sound effects like the airplane in the background. And,
Oh, yeah.
you know, the helicopter. And,
fits perfectly in that song right there, too, don't it?
It does.
Hey, Stan, just before we get started with you, I want to say thank you to those kids that were on a few moments ago from 2nd Street Church of Christ, Jonah Thomas, Anna Gale, and Emma. They did a good job. We enjoyed having them. As we move forward, Stan's going to be talking this morning about another subject, and we'll just hand it right over to you, sir.
Yeah, let me start off with, I've got another one of my seminars on Tuesday coming up, on the 8th. But that's up in Columbia at the Memorial Building up there. So, you know, that's not just for folks in Columbia. If you weren't able to make one of mine down here in Lawrenceburg, I'm going to do that. Just call the office and let us know you're going to come to that. It's up in Columbia. It's at 1 o'clock and 6 o'clock as usual. And then I'm going to do one here in Pulaski on the 19th, which is a Saturday. That's the first time I'm going to do that. We've had, sort of by popular demand, a lot of folks say they can't make it during the week, would like to come. So on the 19th, at the Star Theater, I'm going to do one, that's a Saturday at 10 o'clock in the morning, and we'll have some coffee and donuts there for that. So just call and talk to somebody in the office, and 363-7222 and RSVP for that. So anyway, what we're going to talk about at both those seminars is sort of what I've been talking about the last 3 or 4 weeks. We talked about it, you know, we talked about wills, we talked about revocable living trust, and last week when Jinx was here, we talked a little bit about, you know, why people plan for long-term care. You know, you've heard me say it before, but I'll say it again. One of the most popular questions I get all the time is people ask the question, how do I keep long-term care or the nursing home from getting all my stuff, okay, in one form or another? And that's what we're going to talk about in these seminars. It's what we call it, you know, legally we call it asset protection. But when we talk about long-term care, there's really 2 things that we want to protect it from. You know, the cost of long-term care is catastrophic. Last week we mentioned it's as much as $7,500 to $8,000 a month. So if you do the math, you can figure out how long your estate will last before it's completely exhausted. And we actually went through some statistics that said, you know, 70% of people age 65 and older will require some form of long-term care, which is a pretty scary statistic. And the even scarier one is that 7 out of 10 of those people that do go into a nursing home will become impoverished within 1 year. So those are some. So that's why we plan for long-term care, because we don't know if we're going to be in long-term care or not. I mean, nobody knows. But that's why we plan for it. So there's really 2 things that we need to protect when we talk about protecting for long-term care. There's 2 basic concepts.
Well, you know, a basic question that a lot of people would ask, I think, Stan, would be, how do you protect someone's property from long-term care?
Well, like I say, there's 2 main concerns. One is, you know, if you have property, long-term care can come after it. Okay, and we call that estate recovery, which we'll talk about in just a second. And the other thing we want to protect about is, you know, what everybody refers to as the 5-year look back. The result of the 5-year look back is what we want to avoid against. The 5-year look back period creates what they call a penalty period, which means if you apply for long-term care, if you apply for benefits, you know, like 10 care, you can be disqualified, or they can deny benefits for a period of time called the penalty period. And that's based on any assets that you may have given away. So here's the way it works. If you give something away, they call it an uncompensated transfer. In other words, if you deed your property to your children, you know, for love and affection and token $10, you know, you're giving it away. It's a gift. And you can be penalized for that gift based on the value of it. So they have an equation that they use, or a divisor. It's called the Tennessee Penalty Divisor. based on the value of what you've given away in the last 5 years, they'll divide it by this particular number, and they'll come up with a number of months that you're going to be denied benefits for. So the 5-year look back, or the penalty period, is a result of the 5-year look back. And that's one of the things we want to guard against, because if you have an asset, they can come after it. So what we want to do is we want to give the asset away, and we want to structure it so that we give it away, but we're not subject to the penalty period.
All right, let me ask you this. I've always heard you had to wait 5 years if you gave something away. Is that not true?
Well, there's some truth in that statement, but there's an equation. And the equation is they take the value of what you've given away, and then they divide it by a number. And our number, every state has their own number, but Tennessee's multiple divider, or penalty period divisor, is 6,880 and 80 cents. And so what they'll do is, if you've got, let's just say you have a $210,000 home, we'll take the $210,000, we'll divide it by 6880, which if I round off to 7,000, so I can do it in my head, come up with a number of about 30 months. So they'll penalize you. They'll say, well, we're not going to pay for 30 months because of that transfer. So it's not always 5 years. There is a period, but the period is governed by the amount of the transfer. So if you only gave away like $14,000, I mean, you're only going to be denied benefits for 2 months, divided by 6880. So
right.
It's true, if you give something away, there's going to be a period of, it's going to trigger a period of ineligibility, but that period is not always 5 years or 60 months. It's based on the amount. But another big thing to understand is there's no upper level to that 5 years. Meaning, if you give away $600,000, $700,000, $800,000 worth of property, you can get to 10, 12 years. There's no upside to that. I mean, there's no cutoff from the top. It's unlimited, and that can be a very disastrous effect. And when you're giving away real estate and property, it's not hard to get into those big numbers. So. Anyway, that's one of the biggest things we want to avoid is the penalty period. The second thing we want to avoid is what is called estate recovery. Now, the 10-Care Act has specific rules on what it calls estate recovery. So,
what is estate recovery? Tell us a little bit about that.
All right, estate recovery is it's just kind of like it sounds. What happens is when you go into long-term care, let's say you have a home and you've not given it away. Okay, so you've not really done anything yet. You've done no planning or preparation. And so you have your home and you go to the nursing home. Well, what we can do is, they'll allow you to take the value of that home and put it in the exempt assets column. In other words, it's a $200,000 home. They're not going to say, hey, you own too much. You got to sell that house and spend it down. I mean, some people do that, but it's not a very good idea. But you don't have to. You can move that house into the exempt column, and they won't use it against you for eligibility. Now, those are key words. They won't use it for eligibility. You still have it, and you still own it. They're just not using it against you for the application. Now, after something happens to you, which I'm referring to after you pass away, they now exercise under the 10-Care Act called estate recovery. What that means is they're going to come around because, when your probate estate is filed, we have to file a form with 10-Care requesting a release. That triggers a chain of events where 10-Care looks to see if they ever paid any money on your behalf. And if they did, they're going to exercise a claim on the estate called estate recovery. And because they're the government, they will have a priority claim. So if I leave something to my children and 10-Care has a claim, it doesn't matter what my will says or who I leave it to, they have a priority claim. They're going to get paid first, and they're going to get paid back what we call the cost of care, which means they're just going to get back what they paid out. So that's how they can get the home. They can step in front of them, and that's the estate recovery. That's the second thing we want to guard against. So the way we do that is we do gift away a piece of property, but we gift it to an irrevocable trust. It's called an income-only asset protection trust. And by putting it in this trust, we know that's going to trigger a period of ineligibility. And we do that intentionally. That's on purpose. And so people would ask me, well, why do you intentionally trigger the penalty period? Well, here's the big difference. If you go in the nursing home, the penalty period doesn't even apply until you file the 10-Care application. And you can't file a 10-Care application until you're institutionalized. But what we want to do is we want to put the property, transfer the property to the trust now, trigger the 5 years, and start the clock now while we're healthy. Not when we're in a nursing home and it's in the 5 years, it's too late. I mean, we're stuck with whatever's in that 5 years. We want to start the clock now while we're healthy. So we transfer it to a trust. The goal is try to stay out of the nursing home for 5 years. If not, there's, subject for another radio show, there's many other things we can do if that's not the case. But it solves both problems. One, They can't use the penalty period against you. And second of all, if they want to exercise estate recovery, it's in an asset protection trust for the terms and conditions of that trust. It bars all creditors, and so that they can't get at the property in the trust. So it really is the solution to the long-term care issue. So, and it's the only thing to do when you're pre-planning. In other words, we have two kinds of planning: pre-planning and crisis planning. Pre-planning is when you're not in the nursing home yet, you're not really going there, you're still healthy. Crisis planning is you're already there, and that's a subject for a different radio show, but it really is the only solution there is for long-term care.
So kind of capping it off here, so if you do nothing, you could end up losing everything, right?
That's true. I mean, if you think of it now, if you have nothing in place, everything's exposed. Everything's at risk, meaning if you go in the nursing home and you haven't got anything in the works, you are completely exposed to the estate recovery rule. I mean, there's nothing you can do about it. You can't give it away because it's too late. They'll penalize you for that, and it's too late to protect you from estate recovery. So when you're dealing with long-term care, and when people ask this question, which I started off by telling you this was the most popular question I get, how do I keep the nursing home from getting all my stuff? Well, it requires planning. When I say planning, that means something has to be done in advance, forethought. If we have time to do it, we can protect 100% of what you want. So, I mean, there's lots we can do. We're a little more limited at the 11th hour, but there's still things we can do then too under our crisis planning rules. But so, if you're interested in that, give me a call or come to one of these seminars. That's exactly what we're talking about. I'll quickly go over that again. We're doing one Tuesday, the 8th, which is just Tuesday coming up. It's going to be up in Columbia at the Memorial Building. There's a little room upstairs, but there's a lot of construction around that, but you'll be able to find it. We're doing it at 1 p.m. and at 6 p.m., so you can RSVP for either of those. That's a smaller venue than what the theater and that is, and like over at WKSR, so our numbering is pretty limited there. So if you want to come to that, give us a call, we'll get you on the list. And then I'm doing a Saturday one by popular demand on the 19th, Saturday at 10 a.m. Have some coffee and donuts, and that is going to be right here in Pulaski at the Star Theater. So just call my office at 363-7222, and we'll get you on that list. While I'm finishing up, speaking of Star, Ms. Tammy asked me to point out that the Gatsby show this weekend, that's Friday and Saturday, is sold out. So,
good.
Unfortunately, but we will be doing it again.
I mean, it's good that you sold it out.
This is the second time we did it. We're going to do that, or we'll do some similar ones just like it. There's several of those shows, but they're different themes. This one's in the 1920s, murder mystery. They've got other ones that are different time frames and different themes. But the only thing I want to mention about the theaters, we have that camp for the kids, the summer camp. It's called Under the Sea. Might be a clue as to what an upcoming production might be. But she wanted me to mention that registration ends on the 4th, which is tomorrow. So today's Thursday, tomorrow's Friday. If you want your child to get registered for that, it's got to be by tomorrow, and then they've got to shut that down. So anyway, we talked about a lot of stuff in the last 4 weeks, and we're finishing off with this asset protection. So if any of that stuff that we talked about concerns you, that's all we do at Pierchoski Estate Law and Pierchoski Elder Law is we do planning, we do will planning, we do trust planning, we do asset protection planning, and elder law planning. So if that concerns you, and I'm sure it does because I get asked that question so much, either come to one of my seminars or give me a call over there at 363-7222 on the southeast side of the square, and we'll talk about it. We'll get you set up. There is a solution to this problem.
Very quickly before you go, I have noticed your seminars are growing.
Yeah, we get quite a banner crowd out of them these days, so it may have something to do with everybody wanting to get out.
Yeah.
Usually we stream them, but lately we haven't got much requests for the online version.
Yeah.
People want to get out. We still spread people around and do what you're supposed to do, just in case. But yeah, I mean, it's just a popular topic, and we're here to help. That's what we do. That's all we do, and we've got the solution for your problems. So.
All right. Stan Pierchoski, Pierchoski Estate Law. Thank you, sir, for your segment. And I look forward to seeing you again next Thursday morning.
That's right. I'll be here next Thursday. See you, Rich.
All right. Coming up, we have